Testing, 1, 2. Testing, testing. Testing.
Okay, welcome everyone. We're proud to say that this is the last meeting of any members of council prior to Christmas, and yet we're the fortunate ones that also had the second last, which was Built Heritage. So today is the Court of Revision, and we have 3 items today before us. Are there any declarations of interest? No, I see none. Confirmation of minutes, 26th of September. Thank you for chairing in my absence, Councillor Moffat. Okay, so the first item that we have up is the Farmers Way Local Improvement Extension of the Carlsbad Alternative Standard Water Supply. It's in Cumberland Township. Do we have anyone out to speak to that issue today? Does the committee have, does the court have a desire to have a presentation, brief or otherwise? So the recommendation is that the Court of Revision receives and approves the Local Improvement Special Assessment Roll for the local improvement portion of the extension of Carlsbad Alternative Standard Water Supply and Farmers Way through Thunder Road, previously 9th Line Road, to 830 meters north of Thunder Road as outlined in this report. And we did get communication from a member of the public in opposition. That was from Mr. Anderson. And, pardon? Sure. I'm going to ask Councillor Moffat to speak.
So just for the sake of anyone that actually is here, Mr. Anderson's opposition was with regard to the timeline and the fact that he purchased the property since then, went through the due diligence, got title insurance, but that was not keeping him from having to pay for it. So the motion passed by council on December 11th addresses his issue, and that way the his opposition would pretty much be no longer. So
can we just have a comment on what title insurance is for the few people in the room that may not know?
Madam Chair, when one acquires a house, and this has been the case in Ontario, I'm going to say since sometime early in the last decade, one is able to buy title insurance, which is meant to cover a number of things, such as zoning problems that in the past a lawyer would have gone around and sought particular clearances from the various agencies, and of course there was a cost associated with that, and the thinking is that by buying title insurance it's less expensive than the disbursement and the lawyer's time in doing all those searches. There had been some thought that title insurance would cover local improvements for those who have made purchases subsequent to the approval of the petitions. That did not pan out, and of course council made the decision that it made on December the 11th, that someone who did not know about a local improvement and purchased a house subsequent to it being approved by council and had obtained title insurance would have the collection of the charge waived against them. So for the record, the Court of Revision still imposes the charge against that property, but council's decision is that the collection of that charge is waived.
Thank you. Anyone have any questions about that? So on this item, understanding that the gentleman we did hear from will be, his concerns will be addressed with the approval by council last week. Is that item carried? Carried, thank you. So second item is the Innes Road Sanitary Sewer Local Improvement, Section C, Belcourt Boulevard, to 795 meters west. We do have a speaker, and I think we'll have a very brief presentation, and we do have the Councillor Blois is here as well. So on this one, we're going to be asked that the Court of Revision receives and approves the Local Improvement Special Assessment Roll for Section C of the Innes Road Sanitary Sewer Local Improvement Project, as outlined in this report.
So, Madam Chair, we'll start the presentation. Kelly will do the presentation. Presentation essentially covered all 6 areas of the Innes Road local improvement. What we will do for the purpose of this presentation is just focus on the 2 that is coming before you today, as the others did not receive any objections, therefore technically were approved.
Okay, thank you. Sorry. Technical difficulties. We'll do a little bit of background on the Innes Road project, and then, as Alain mentioned, we'll speak specifically to Part C. So the Innes Road project is a little bit different than the previous local improvements that the court and committee may have heard so far. In 2004, there was a Canada Infrastructure Program, and the city was successful in securing some funding through that. That project was essentially for the widening of Innes Road from Orleans Boulevard easterly to Trim Road, quite a distance. In that stretch, there were, at the time, 60 to 70 properties that currently did not have, or at the time did not have, sanitary sewer services available to them. And there were obviously reasons, compelling reasons, to try and undertake the work at the same time as the road was being constructed. Part of it is that once the road was reconstructed, the next time the city saw any kind of road works happening would be 15 years into the future. And with the widening of the road, there was good potential that people would want at some point to take advantage of the sanitary sewers and didn't want to damage the roads that were just freshly reconstructed. Because they were large projects, the reconstruction projects, it was obvious to us that, or the city, I should say, that there would be significant cost savings to the property owners because of the scale of the projects, and obviously better prices from contractors. So what council approved in 2004 was to undertake the work through council initiative, and that required applying to the OMB. In other words, it's not petition work, it was work initiated by the city. That required passing a bylaw to undertake the work as a local improvement and getting council's authority to apply to the OMB, and also obviously agreeing to charge the cost back to the property owners. The project, as you heard briefly, was actually 6 distinct sections, again, generally around intersecting streets, so Paget Road, Boyer, Bedcool, Prestwick, 10th Line, and Darima. The 2 sections that received objections were the 3rd and 4th, Section C at Belcourt Boulevard and Section D at Prestwick. A little bit hard to see in the picture here, but essentially those were the 6 distinct sections, so pretty much spanning from Paget Road to just east of 10th Line at Darima Street. There were 2 separate construction contracts for the roadway, but the works were incorporated within them. So the project for Innes Road, all 6 of them were undertaken under the Municipal Act, Ontario Regulation 11903. It was for sanitary sewers and the service connections up to the property line, and it was, as I mentioned earlier, a council initiative, which means it was not petitioned. In June of 2004, council approved moving forward with the work as a local improvement by applying to the Ontario Municipal Board. Shortly thereafter, there was public notice of the city's intent to apply to the OMB. There was a period of time where owners who had issues could meet with the city and discuss those issues. At the end of that time frame, none of the objections, or no objections, I should say, went to the OMB. The application proceeded, OMB approved the works, and the bylaws were enacted in December of 2004 and January 2005. So some of the special considerations, 11903, the Ontario regulation, had provisions that the cost of the works that abut intersections was to be borne by the city. There are also a number of properties on predominantly on the north side, but a few on the south side of Innes that had already been serviced through other means, either through existing development or through ongoing commercial development. So the city is bearing those costs. This particular project was undertaken on the basis of frontage only. As you heard in previous projects, there was area and value, but this one was straight frontage. A little bit of footnote, what we will do, staff will do, is amend the sewer connection bylaw such that any of those properties that the city has had to pay because they were had servicing by alternate means, if at any time in the future that property in fact comes forward to connect to the sanitary sewer on Innes Road, they will have to pay a charge as everybody else did. In addition to that, as you're well aware, the properties on Innes Road for the local improvements are subject to the council motions, policy motions adopted over the course of 2013. Those of the tax certificates, the recent one on title insurance, as well as the interest relief motion that was passed June 12th of 2013. So all of those are in play for these local improvements. A small change since the information went out to the residents. They may not actually have even picked up on it, but we noticed that the special assessment roll that had been made available to the public was lacking a note on the those dispensation motions, and we corrected that, and the corrected version is what's in fact in the report in front of you today. So Part C, I believe this is the, we have a speaker here today on this, but Part C, a little bit hard to see, but it's essentially Belcourt Boulevard was where the outlet was, and I think it was short, just short of 800 meters of sanitary sewer that was installed, draining from west to east and outletting down Belcourt Boulevard. The property, I believe, that has concern is this long and fairly large parcel. It was constructed, the project was undertaken between 04 and 06, two large projects, as I mentioned. The bylaw for Part C was 204 of 592. Essentially, the cost apportionment was that the residents would pay for the sewer main service lateral to the property line and the area impacted by the sewer construction. Beyond that, it was all city cost. Bylaw, this particular bylaw had specifics around the estimates at the time. The estimates at the time had some fairly conservative numbers there because it was presence of rock, and it wasn't sure whether that would come into play or not during construction. At the end of the day, the final construction for Section C was just under $342,000. $245,000 of that is being assessed back to the property owners, and about $97,000 is being paid for by the city. The second section of local improvements that did have an inquiry prior to the sitting of the court today was Section D. Section D is largely centered around Prestwick, and it had an extension to the west of Prestwick and a short stub to the east of Prestwick. The property, I believe, that had the inquiry is about 2 east of Prestwick Drive on the north side. It's a vacant lot, formerly 4315 Innes Road. Again, the work was undertaken between 2004 and 2006. Bylaw for this one was 20529. It was passed in January of 2005. Same cost apportionment principles. At the end of the day, Part D cost $147,304 and some change. Of that, $98,000 is being assessed to the property owners, and $49,000 is being covered by the city. That is the short presentation on the 2 sections of Innes Road.
No? None? Thank you for your presentation. So I'm going to ask Ms. Sharon, Carmen Sharon, and you come right up here to this mic that you'll, whoa, are you okay?
We're a small group.
We're very small. We're not even so sure we're mighty.
son is just playing games on his computer, so don't worry about it.
Never mind. Welcome. Just tell us, just think of it that you're going to tell us a story, okay? And then it will be, we're having tea and you're going to tell me a little story, okay?
Well, actually, it's a bit of a sad story. But it involves a very old aunt at the time. And first of all, she had been approached to sell 17 acres on Renault Road to Richcraft. And she was told that she would have, in order for that to be authorized, she would have to give frontage on Innes Road for the widening of the road. And I don't think that's very fair. Anyway, they took over 30 feet of the frontage, so she was not expropriated. She had to convey, I believe is the word they used, whereas the neighbors were expropriated. And my next door neighbor, not only was the property expropriated, but they were exonerated from this cost. And it's 3676 Innes Road, Grew family, okay? I have nothing against them, but I just think it was very unfair. And then my aunt's house, which dates back to 1850, is 800 feet from Innes Road. So she was not to connect to this sewage system. She has a septic tank, and it was all she needed. And I am pretty sure there was a verbal agreement with somebody at the time that she would not have to pay this cost. And on the document that I received, it says that there is one connection, and I don't know where it is. Where can I find
Did you
that?
say you don't know where it is?
Not at all.
Okay. Continue with your comments and I'll get you some answers.
Okay.
Unless that's all you have to tell us.
Well, it's almost all I have to say, but I would like to say, though, that the amount requested from the estate is very big, because it is a very small estate. My aunt was not rich, believe me. And
You still are one of the beneficiaries of the land?
I am the
That property that we know?
I'm the executor of her will, wherein it states that the property should be sold. But not only did they take 30 feet from her on the frontage, but also there's a holding on that property. And I don't think that's fair either. Why? I don't know. And also, she had to sign a document wherein she was reserving land for the, what do they call that? The Blackburn
Bypass?
Hamlet bypass extension and the future Cumberland Transit Way. And on that property, there is also gosh, I don't know how to say it, des servitudes, we say in French. It's hydro. And they take up 2.39 acres of land. I think my aunt has given enough. Franchement, là,
That's okay.
I
Let me find some answers, okay, on what you were talking about. I'm going to go to Mr. Mark. Are you the person I should go to? About
Madam Chair,
easements and about the expropriation or not, et cetera?
I can start off on that, and I, Madame Sharon and I had a very pleasant conversation, so this will not be news to her. When the, as Mr. Martin pointed out in his presentation, this was a city-initiated local improvement, and so we had to apply to the Ontario Municipal Board for approval. Mr. Martin was correct in that there was never ultimately any Ontario Municipal Board hearing, but there were appeals that were filed, and there were discussions held with respect to those appeals, and with respect to both the combination of the expropriation of the property next door and the appeal. The resolution of that one was that the local improvement charge would not be levied against the property next door, and so that's how that particular result came about. With respect to the lateral question and its location, I turn that over to Mr. Gontier and Mr. Martin.
Yes, the service lateral that would have been dropped off is within the road allowance.
Can you speak a bit louder, please?
Oh, sorry, okay. The service lateral that would have been dropped off is within the road allowance, so it's in the paved portion of the roadway. It wasn't to connect the existing house, it was really to provide that potential of a connection for anybody who wanted to connect in the future. So it's basically, if you look at Innes Road, it'll be roughly from the center of the road to the property line is roughly where it's at.
But my neighbor does not have a connection.
No, 3676 would not have been provided that connection.
Can I ask why?
It was because they weren't paying for it.
Because what he's not telling you, unless somebody has told you this, is that your aunt actually did sign and say that she wanted it. Whereas if you look at this document, we have people at 3676 who said no lateral installed via local improvement, 3681, 3698. There's several of them in a row that, well, not in a row necessarily, but did say that they weren't interested in having that. So she did sign something that said that she wanted it.
I don't think so.
Well, whether you think so or not, it wouldn't be in here if we didn't have that document that she did sign. What year would that have been done in?
2004.
I can't understand why she would sign that document, you know, because she did not intend to use it. She had a septic tank and a well, and that was all that was required.
Usually, I don't know how the Blackburn bypass ties into this, and the
That's Mr.
expropriation-
Chiarelli,
no,
the regional municipality.
yeah. I mean,
Wait.
we know a lot about the Blackburn bypass, but I don't know how it ties into this location at all. Councillor Kadri?
Thank you, Madam Chair. Just a question coming back to staff. When this work was being carried on, when the petition was signed, would we, as a record, have copies of that petition?
So, Madam Chair, that's why I want to come back. There was not a petition for this work. This was the alternate procedure under the Local Improvement Act, which was municipally initiated, and with the municipally initiated work, there isn't a collection of two-thirds of signatures from two-thirds of the property owners having 50% of the assessment. The municipality applies to the Ontario Municipal Board. There's an ad that goes in the newspapers, and people have the right to object if they wish. And there were objections on two of the segments, as I recall. Those objections were resolved, and as Mr. Martin said, nothing ultimately went to a hearing in front of the board.
Thank you, Mr. Martin.
Oh, sorry, go ahead. I think the confusion is, if you look at the local improvement special assessment roll, and the sewer lateral component, and the addresses that say no lateral installed via local improvement, why does your aunt's location not say that? What was the difference? Because?
The property owners that were being assessed, or let me put it this way, the properties where there were no service laterals dropped off is because they had ability to service otherwise. So it was either through existing, they'd already connected, or they could connect internally. For example, down by Prestwick, Delancier Drive area, there was a commercial development underway at the time, and that was serviced internally rather than through Innes Road. In addition to that, if a property was not being assessed the cost of the work, we would not have dropped off a service connection.
Can you put up the slide that had the property in question on it, and then the one beside it? I just want to compare which one.
Okay. So, sorry, this would be 3672,
72,
Right.
and 3676 is here, I believe,
Is what?
right next to it.
Right, and so that one, for example, has no lateral installed via local improvement. What's the difference? Because it also said it's formerly vacant lot.
3676 was subject to the agreement as Mr. Mark indicated, as a result of the expropriation and OMB period appeal during 2004 when the work was being planned.
When the what was being done?
When the work was being planned and we were preparing to apply to the OMB, there were several things happening. The expropriations, as were required to widen Innes Road, as well as the appeal period for the OMB application. As a result of both of those things happening, 3676 was exempt from the local improvement charge.
Did the owners of 3676 through the expropriation get any money at all?
they did.
Madam Chair, I have to think that they did, but I don't have that information available in front of
So
me.
my question really is, how did we have this one piece of land owned by Ms. Charon's aunt that was treated differently when it really is right beside it? Why was the lateral dropped? Why was it not expropriated? And why did she not receive any money? I mean, you were telling us about Renault Road and Richcraft and the deal and all that kind of stuff. I'm sure that in some way that plays into it, but not for what we have before us today. So who in the room can comment on those things?
Madam Chair, there was, based on what Madame Charon has said, there was an application for a severance made to the Committee of Adjustment to permit a conveyance to Richcraft Road. Consistent with the practice on consents all the time, I would have been a condition of that consent that the frontage along Innes Road identified in the official plan, whatever it was, be conveyed to the city at no cost. Because the adjoining landowner wasn't going through a consent process, therefore the property would have been expropriated from them, and while I don't have the information in front of me, my full expectation is that they received market value for that expropriation. They, through the process that when the city advertised in the newspapers for objections to the local improvement, there would have been there were discussions that took place at that time, and so as through the combination of the expropriation and local improvement process at the time, that's how a resolution was arrived at that they wouldn't pay the local improvement charge. They were acting on the tools that they had available to them because they hadn't had to go for a consent to sever.
Okay. So here we are today in a situation where we have one person that has written and has come out to talk to us about this. And one of the questions I have is, in my experience, anyways, back in Nepean, when we had but we had servicing done on Winding Way, for example, when Minto came in along Prince of Wales and started to build the mansions, if you will. The people along Winding Way did sign a petition so that they could be part of that, and the percentage that was necessary was achieved, but not everyone approved of it. So they had an option that would, whenever they did want to hook into it, whenever that time was, that's when they would pay their part or their share, which caused us still to have dropped the lateral in to connect to the other one, so there was the consistent flow, but the people in those properties did not pay. And I don't know that all of them have hooked in to this day. So would there be an opportunity in this case with this property at 3672 in this road to say, clearly, this property is going to be sold? Even when your aunt was alive, she was looking to sell it. Clearly, it's going to be sold. Well, she had a deal with Richcraft, you told us.
Well, for the end.
I know.
On renewal.
Exactly. So clearly, it's going to be sold. It's not going to be saved. No, anyone living there now?
Well, it's going to be sold if there's a miracle happening. I have it for sale, but because there's a holding on it and so many...
Okay, hang on now. Why is there a holding on it? Do we know that?
Don't know. It's...
I'm not asking... I know you don't. I'm asking, like, we have people in the room that might know. But it's not you, and it's not me.
Well, I can tell you a little story. A number of years ago...
So Councillor Moffat is looking at Google Map. Geo Ottawa. Hang on a second.
Oh.
Councillor Bloss, do you know about the holding provisions here? So it's the Patterson land and it's all ties into this?
Of what?
Okay.
Excuse me?
No, just...
No, he said because of...
No, don't...
Oh, just because she's
Yeah.
Didn't understand.
Did you hear what he said?
No.
That's okay. We're going to get some information from our lawyer, okay? From the city lawyer?
Sorry,
Hang on a
okay.
second.
Madam Chair, I recall looking at this after I had the telephone conversation with Madame Charon. The zoning code I see is a IL2H height 14-H, and I actually recall looking at it when I went to look for the reason why the H was on it, and I did not find it, Madam Chair. Yeah, I did not find, because you'll notice, or if you've seen what's on the screen, there's no exception number associated with it that would tell you the reason for the H. And so I was not able to find the reason for the H. Madam Chair, may I, if I can respond to one of the comments by the Chair. The court could come to a conclusion, if it wished, that this property presently does not benefit from the local improvement, and that would allow staff to come forward with a report, which we were intending to do, as Ms. Martin identified, that would say, when you connect, you have to pay the charge.
Which is, I know that's where I want to go with it.
Yeah,
but I don't know about the rest of the court members here.
And Three Winding Way is an example where staff, that's one of the properties that staff will be coming forward to include in a report, picking up similar properties in the local improvement areas in 2014.
Okay. Thank you very much for coming out, Madame Charon. Thank you. And could you turn the mic off, please, and go back and take your seat? Thank you. Anybody have any questions of Madame Charon before she sits down? No? No, it's okay. The way that it works here is we have a presentation. You did a great job. Thank you. It generated lots of questions. And now we come back and we have a chat here at the court. So thank you very much. And thank you. Okay, so coming back into court, unless somebody has any other questions, thank you for that, because that's exactly where I believed, in my experience, that it would be a fair thing to do. So Any of the other members of the court want to speak to this? Because I'm going to be looking for a motion, and it would tie into the report that you're doing already.
So, Madam Chair, the court may wish to consider a motion concluding that the Court of Revision, and I'm hoping that Ms. Theriault can follow me as I'm talking.
Sorry?
I'm hoping that Ms. Theriault can follow me as I'm talking.
Yes. She's moving from hand to type.
That the Court of Revision is of the view that 3672 Innes Road does not benefit from the Innes Road sanitary sewer local improvement, and therefore amends the charge for the mainline sewer and lateral to zero until such time as a property does benefit.
Until such time as the property does benefit.
Yes, and so it would actually be, that's to provide a history to it. It would actually have to be council that would impose that charge at a future date, and as I mentioned, staff are working on that. I'm meeting with infrastructure services staff in January.
So it would be somewhat of an anomaly report that would come with several to council?
There are several in Innis. There's one on Winding Way that I know of, and I'm meeting with Ms. Gill so that we identify all of them so that there's one report and they're all dealt with.
And when are you expecting that to come forward?
I've not discussed that with senior management. I would expect a second quarter, 2014. Okay,
so over to Ms. Bradley. I think we should go over to you now. Do we need to have a motion that is specific to what the comments of Mr. Mark is, in addition to the motion that he just said, but as it relates to this property?
It's a question whether you need a further motion than that was suggested by Mr. Mark?
Exactly. That one's going to take it to council with other properties in the city. But do we need anything to close today and this particular issue?
I don't think so, because Mr. Mark's motion includes applying a zero value to this property, and it's what is proposed by Mr. Mark is also addressed on page 3 of your report, if you choose to look at it, for properties that were serviced by other means, and actually does already establish a means by which connections could be made in the future for certain properties that were serviced by other means.
Good, thank you. Anyone else on the court court members have any questions? No. So would one of you entertain moving the motion as recommended? Okay. Councillor Kadri, moved by Councillor Kadri, and this is where you listen, Madame Charon, because this gives you the information, okay? That the Court of Revision, us, is of the view that 3672 Innis Road, we'll give you a copy so you don't need to write it down, okay? Oh, good for you. That property does not benefit from the Innis Road local improvement, and therefore amends the charge for the mainline sewer and lateral to $0 until such time as the property does benefit. So that cost will stay with the property. We just won't be looking for the money today. Okay? Is that clear, everybody? Say on the motion. Carried. Thank you very much for coming out today. If you have any other questions, there are people here that will help you with that. Okay, thank you. And you already know their number because you've been speaking to them. So thanks very much. Okay, so we'll go on to number 3 now.
Madam Chair?
Yes.
Could I ask the Court of Revision to carry Section C as amended?
Okay. Yeah. So does the Court of Revision accept, we're carrying Section C as amended? Carried? Thank you. Okay. So our last item today, and I don't think we have any other speakers in the room, but we did have some correspondence. This is with regard to Section D, which we've already had a presentation on from Mr. Martin. Innes Road, this is in Councillor Blaise area. Innes Road sanitary sewer local improvement, the other side of where, along Innes Road, Prestwick Drive to 240 meters west and 75 meters east. And does anyone have any questions? No? And so the motion before us is that the Court of Revision receives and approves the local improvement special assessment roll for Section D of the Innes Road Sanitary Sewer Local Improvement Project as outlined in this report. Is that carried? Carried, thank you. Good work. And I'm happy to say that unless you have some other business, no, we are adjourned. Thanks, everybody, for your efforts today. Thank you, Madame Sharon, for coming out.